right. Good news. Good news, people. Hello. I'm Otis Landerholm. I'm the founding attorney here at Landerholm Immigration A.P.C, where we fight for your American dream. And I've got good news today for you visa holders. All right. For those who aren't aware, U visas are visas for people who have been the victims of crimes here in the United States. It is not fun to be the victim of a crime here in the United States, but I've got good news for people who have applied for U visas. Many people who have applied since 2015, 16, 17, 18, 19, 20, 21 have been waiting and waiting and waiting and waiting for U visas to be finally approved, because they take a long time. And many, people who apply for a U visa today, it could be pending for 10, 12, 13, 15 years before it is approved. But today, finally, there's some positive news. And so what is that positive news? Well, it's a process. And what that process is, it is that the government is going to be allowing people with pending U visas to apply for work permits while the U visa is pending. And I want to show you what they're saying. All right. So don't take my word for it. Take the word from the memo itself, from the Department of Homeland Security itself. I hope you can see my screen. I'll move my talking head over here as well. So this is a policy alert, came out June 14th, 2021. That is the day that I'm recording this. It came out today, everybody. And this is policy alert. Subject: bona fide determination process for victims of qualifying crimes and employment authorization and deferred action for certain petitioners. All right. Purpose: USCIS is publishing guidance in the U.S. Policy Manual on employment authorization and deferred action for principal petitioners for U non-immigrant status and qualifying family members with pending bona fide petitions. All right, I'm going to keep going. All right. U non-immigrant status, this is the background. U non-immigrant status is available to non-citizens who've been the victims of certain crimes, including domestic violence and sexual assault, along with lots of other qualifying crimes for U visas, and who are or have been helpful to law enforcement in the prosecution or the investigation of those crimes. A non-citizen granted U1 non-immigrant status as a principal petitioner is authorized to work based on that status. That's true. If your case is approved, you're authorized to work. All right. USCIS automatically issues an employment authorization to principal petitioners upon the approval of their petition for U non-immigrant status, upon the approval of their Form I-918. All right. And if the number of approvable petitions exceeds the annual visa cap allocation, which remember is 10,000 visas per year, USCIS places approvable petitions on a waiting list. And then USCIS grants deferred action, or in limited circumstances, parole to U1 principal petitioners and qualifying family members on that waiting list. And USCIS may, as a matter of discretion, also authorize employment for such petitioners and qualifying family members. USCIS generally provides such employment authorization under 8 Code of Federal Regulations, 8 CFR 274A.12C14, which is employment authorization category C14. USCIS may also provide employment authorization under INA 214P6, but it has not done so historically until now. All right. Due to drastic increases in the volume of U non-immigrant petitions and a growing backlog awaiting placement on the waiting list for final adjudication, USCIS has decided to exercise its discretion under INA section 214P6 to conduct quote unquote bona fide determinations, BFD. Pay attention to this. Bona fide determinations, and provide EADs, work permits, work permits, and deferred action to non-citizens with pending bona fide petitions who meet certain discretionary standards. The guidance contained in Volume 3 of the Policy Manual updates and replaces Chapter 29.1D2 and Chapter 39.1F of the Adjudicator's Field Manual, the AFM, all right? As well as the AFM's related appendices and related policy memoranda. USCIS is implementing this guidance immediately, and the guidance applies to all Form I-918 petitions that are currently pending or filed on or after June 14th, 2021. The guidance contained in the policy memo or the policy manual is controlling and supersedes any related prior guidance. Policy highlights. All right. First bullet point. This provides that USCIS conducts an initial review of Form I-918 and will issue BFD, bona fide determination EADs, employment authorization documents, and deferred action for 4 years to petitioners for non-immigrant status and qualified family members if USCIS deems their petition quote unquote bona fide instead of completing a full waitlist adjudication. What does that say? What does that say? That says that if you have a bona fide application for a U visa, all right, they'll review your application. They'll see, hey, is it really a bona fide application? And if they say that, they're going to give you a 4-year work permit. That's awesome. Renewable after 4 years. All right. That's awesome. While your U visa is pending. All right. This is a U visa petitioner, not a approved, already been adjudicated U visa holder. This is someone applying for and who has a good faith showing that they have a good faith application for a U visa. Awesome. Second bullet point is clarifies that if USCIS determines the principal petition is quote unquote bona fide, USCIS will then determine whether the principal petitioner poses a risk to national security, public safety, and finally, whether the principal petitioner warrants a favorable exercise of discretion to receive employment authorization and deferred action. So if you've got crimes and other things, you might not be eligible for this work permit. All right. It explains that those who do not receive a bona fide determination work permit under this initial review will proceed to full waiting list adjudication. And if their petitions are approvable, will be placed on the waiting list for a U visa. In other words, for example, if you have a criminal record or if you're found to be a risk to national security, you might not pass an exercise of discretion under the bona fide determination, but you might still eventually be put on the wait list if you're found that you have a U visa that's approvable. All right. Third, it explains that those who do not receive a bona fide work permit under this initial review will proceed to the full wait list adjudication if their petitions are approvable, will be placed on the waiting list for a U visa. I may have just read that. Okay. Very good. And if they have properly filed employment authorization, they also receive an employment authorization document valid for 4 years. Okay, great. Provides that USCIS, number 4, provides that USCIS will generally not conduct waiting list adjudications for non-citizens who have been granted a bona fide determination EAD and deferred action. And instead, their next adjudicative step will be the final adjudication for U visa non-immigrant status when space is available under the statutory cap. What's that say? Basically, if you're getting one of these bona fide determination work permits, they're not going to go through the second step of also giving you a wait list work permit under C14. They'll just give it to you under 214P6. All right. So got it. Cool. And then the next 3 steps to clarify, I believe this is bullet point number 5, explains that throughout the initial 4-year validity period for the bona fide determination EAD and the grant of deferred action until the final adjudication for non-immigrant status, USCIS will update and review background checks at regular intervals to determine whether a principal petitioner or qualifying family member may maintain his or her bona fide determination EAD and deferred action. What's that saying? It's saying that if they give you one of these work permits, you got to maintain it. They're going to continue to run your background checks so that if you were to be arrested, if you were to have some kind of issue with law enforcement, if you were found to be a gang member or anything like that, they can take it away. What they give, they can take it away. That's what they're saying. USCIS also retains discretion to update background and security checks at any time when case-specific circumstances warrant it. All right, got it? The next bullet point clarifies that USCIS will review all petitions, both petitioners waiting on the waiting list and petitioners issued bona fide determination work permits in receipt date order for final adjudication of U non-immigrant status. So basically, whenever you applied for a U visa, you're still in the line. All right, doesn't change your, you're still in receipt date order for the final adjudication of the U visa. And this is a really great point. I'm glad they're making it. Lastly, it clarifies that USCIS is adopting the decision issued by the Ninth Circuit in a recent case, Medina Tobar versus Zuchowski, for nationwide application. This case, well, I'll continue reading, then we can talk about it. Therefore, when confirming a relationship between the principal and the qualifying family member that's based on a marriage, USCIS will evaluate whether the relationship existed at the time the principal petition was favorably adjudicated, not at the time that the principal petition was filed. All right? So if you get married after you file, but before it's adjudicated, you can include your spouse. That's what this is saying. If you file a U visa and 2 years later you fall in love and you get married, you can include your spouse in your U visa. You don't have to wait and to do it after the fact. Very cool. This is a great memo. This is good news for U visa holders throughout the United States. If you're a U visa holder, you might be able to get a work permit while your U visa is pending much faster than what we ever saw before. All right. And so thank you, Department of Homeland Security. Thank you to those involved in creating this policy alert and this update to USCIS policy. Thank you to USCIS. Yes, I said it. I am an immigration lawyer and I am thanking USCIS and USCIS leadership for doing something to actually give a benefit to people with pending U visas and addressing this issue, because it's been horrible, to be quite honest. And if you've got a pending U visa and if you've had one for years, you know what I'm talking about. It has been horrible. And so now finally they'll be adjudicating some work permits at least while, we're still waiting for the U visa itself to be adjudicated. Thanks a lot. Thanks for watching. If you have questions about your U visa, or if you might be eligible for a U visa, hey, please feel free to pick up the phone and to call my office. We do a lot of U visas. And if you are our client and if you might benefit from this, be on the alert, because we might be reaching out to you and hopefully we'll have good news for you about your case here pretty soon. Thanks so much for being with me. I'm Otis Landerholm, Landerholm Immigration, A.P.C, where we fight for your American dream. Thanks a lot. Bye-bye.